At Buganda Road Magistrates Court, former Deputy Lubaga Division RCC Anderson Burora faces 18 counts of hate speech and spreading malicious information against the Speaker of Parliament, Anita Among.
They have guided on the law.
Prosecution led by Richard Vomboka initially objected to Burora's bail application, citing insufficient sureties and lack of fixed price overboard.
In the case of criminal application number 23 of 2023, criminal application number. Josh. All right. Okay, fine. That was out of yours. We can do this one. That is the one. Criminal application number 23 of 2003. That is Tigawalana, Baka Ikoba versus Uganda. Your worship, I would refer to page 10. I will refer to page 10. Specifically, the second paragraph. And I quote, the observation of Justice Sayadana are relevant in this case. The judge was dealing with a situation involving prominent politicians and professional persons. I am now in this application dealing with a bail application involving a young man, educated and prominent politician. He has a lot to fear and a lot to lose. When and if he has to face the judge now, preferred against him, he would do anything and go to any length to avoid or avert the proceedings now hanging on his neck. This may involve or include absconding or asserting his influence on the would-be prosecution witnesses. These are not my words, Your Worship. These are words.
And was the judge wrong?
Yes, the man was wrong. So, Your Worship, our submission is that the applicant is a politician. The applicant is a young man. The applicant is prominent or eminent. The chances of him absconding this trial are so high. They are so high. The fact that he's charged with 8 counts, Your Worship, I want to give you an authority. High Court, criminal case number 0266 of 2022. He was sentenced to 105 years, and those are still because the sentence was consecutive. I'm not arguing that the applicant is guilty. My argument is that if the accused person is convicted and sentenced to consecutive, sentenced and sentenced to run consecutively, then the sentence would be so high, and he wouldn't wish to go through that process. Your Worship, so it is a prayer that court finds that the sheet is presented by the applicant are not substantial, they have no fixed place of abode, no financial ability, they have forged letters, there's no marriage between the applicant and sheet number 1, and Your Worship, prosecution adduced this through the affidavit of one Detective Corporal Nyakato, which is on the fire. Nyakato, Anet, Karera, and the applicant never rebutted the contents.
I'll conclude now.
This is a serious matter. Yes, and it may exalt the Supreme Court or Court of Appeal. So we want to be put on record, and we shouldn't be blamed for strangling the law, because we might even meet it there when we are there. So, where did you stop?
So when the police approach their submissions,
We had closed the pleadings and also closed our submission. The defense only had an opportunity to do that. Initially, when the matter came up today and they were served with an affidavit, in the morning. That's when they were supposed to make a reply. And another opportunity was when they came back and said, you know what, we will seek leave of court before we even submit. But they were simply awakened up by, they woke up because we were informed about Africa. So the issue is what is the fate of our submissions and the pleadings which have been closed. The new application
of our submissions
and the pleadings.
in light of their prayer.
In light of their prayer. So, the effect is that court has to make a decision, first of all, on the pleadings and their submissions. And we submitted one affidavit, and affidavit touched so many people. It touched not only the applicant, but it touched the sureties, it touched the LCs, and the church. It is not something that you can simply do within 1 hour also. Now, the effect, what is the way forward in our submission is that this application has to be disposed of before that application. The only remedy the defense has is to file a fresh application. They withdraw this one. Short of that, any documents filed, even when court says file, they will be tantamount to a fresh application. It will have no bearing on the documents and the submissions by the defense. I mean, by the respondent. And there has been no rebuttal legally. There has been no rebuttal legally. This application is misplaced. It is in bad faith. It's an abuse of the court process, and an abuse of court process what was defined. I want to give you a suggestion.
There are so many things here.
Yes, this is an abuse of the court process and fishing expedition, legal fishing expedition. I have failed it. Let me try here. Yes. And on that note, we pray that this court dismisses that application. But in the event that this court is inclined to allow it, we pray to have for the ruling immediately of court. Because this is against the law which was supposed to protect in the Constitution.
Burora's legal team countered the objection.
Your Worship, we pray that the documents furnished by the sureties have been verified, being found authentic.
What my brother has to speak is the law. I want to make this point clear. Yes, I want to make this point clear. When it cannot come up in rejoinder because we assume what he spoke ended there and ended without evidence and is on record. He does not have to reply anything to do with the shooting because we have already tainted them. And that is a matter of fact. Secondly, he cannot speak to anything which is not legal. He is only limited to legal point. Short of that, you are going to object until Jesus comes back.
Your Worship, while he wanted to gag me, his position was a good chance of mark, but not affecting my rights. Your Worship, actually, I have attitude even to bring back the partition on the sureties as long as he talked about them. Because Your Worship, when my Ran's brother made his submissions, he did not limit himself to the affidavit. He made a wide range of commentary. And Your Worship, we pray that our Ran brother also refrains himself and allows us to make necessary reply. So, Your Worship, the sureties have their documents on court record. Your Worship, we pray that those documents be perused by this honorable court and be found authentic and substantial. Your Worship, when this matter was last adjourned, State was given a right to go and verify documents. As intimated by State, the documents were found.
I think you want to make me stand again. Your Worship, our submission is that nothing to do with that should be done. Because we need to uphold the law as it is. There are so many times in this courtroom who should know the procedures. They shouldn't go ahead and say that Billy told to me a procedure, which is wrong. If my brother cannot restrict himself to the legal issues, then he would rather close his matter.
Your Worship, in addition to LOC letters, documents of his company, he furnished company.
I'll yet to write because I want to see if
Your Worship, he furnished a certificate of operation
because I propose to the order I have anything.
and the notification of appointment of directors. Your Worship, what I need to point out is that my young brother deliberately mutilated documents we submitted. He got the notification of appointment of directors, which had part A and part B, and he made it to be two different documents when it was only one form. He made one form to be two documents.
Why did he tell that he come to court via an affidavit?
Your Worship, that
You
is a
see,
technical point I have a right to
just a
reply
minute.
to.
Just a
It's a
minute.
technical point.
I
It's
think
a document I furnished.
Your Worship,
He has changed its identity.
we should have a standing on what we are supposed to do.
Your Worship, it's a document I furnished. He has changed its identity. The document has been changed its identity. It has the first page and second page.
And it is
Your Worship, I want to go to that.
it is contempt of court when a ruling has been made that you shouldn't submit on facts and proceed.
Your Worship,
And you so don't and you go ahead to submit on facts. What is
Submitting
supposed
on my
to do
document,
is
not
submit
another
on the
document.
legal bit of it. We have no problem with that. Submit on the
At least I know
legal.
those documents. I can know it was one document.
yes, Your Worship, this document, which is notification of appointment of directors, it had 2 pages. But Your Worship, when the state was releasing him in court, he made it to be 2 different documents.
That
By
has
the
been
fifth.
noted.
Yes.
That has been noted.
So we pray that you find the surety is substantial, Your Worship, and you accordingly grant bail. Your Worship, my young brother has a few additions to make.
Alan Musasi, Worship. Your Worship, in those our submissions, we are codified by the provisions of the Constitution, and also Section 15(1) the Constitutional Guidelines for Courts of Judicature, practice April 2022. Your Worship, qualifications thereunder the court to consider are the age, place of work, place of residence, character, the relationship of the surety with the accused person. We have provided all this to this honorable court, and the Worship, the section further requires that a copy of the national identity card of the surety be provided, same as we provided, and an introductory letter from the OC1 area. All those, Your Worship, have been produced. Your Worship, we are also fortified by section.
Your Worship, before you proceed, when the matter came up for bail application, all that my brother is submitting, just a minute, give me audience, that is submitting on, were submitted on. And we never said anything about what is submitting that law in our reply. He would only have locus to submit on the law,
It was not,
which
it was not in the court that day.
it wasn't it. So he's only supposed to reply on a matter of law which came up in the rejoinder. A matter of law. So whatever he mentioned, he alluded to in the application is good, but not for now. It is for another day. So we pray that he is restricted to only the reply of prosecution but on law.
Sounds asking. Those matters were argued when you were not here. I don't know why it is something.
To address is in regard to the issue that came up with documents that were submitted, council submitted at the same point. We wanted to make a submission on a point of law, Your Worship, that relates to forgery court documents. That's all we want to do, Your Worship. With leave of court, we beg to proceed. Your Worship, call upon this Honorable Court to consider all the documents that were submitted by the applicant to be found authentic, as provided for under Section 43 of the Evidence Act, which provides that the only proof of the handwriting can be done by an expert.
Before it proceeds, he has a right to only submit on a matter of law on something which has been not mentioned in the affidavit. The issue of sureties was mentioned in the affidavit. Now, for you to come and dismantle those kind of facts with evidence, you need first of all reply through an affidavit. Then you get a legal way of answering legally. For now, it's bad. I know he's bringing the issue of law, but the law is connected to the affidavit, which is already on record and unchallenged.
May I proceed?
No.
Thank you very much, Your Worship. Section 43 of the Evidence Act, Cap 8 now, Your Worship, provides that the authenticity of a document can be proved by a handwriting expert, and this can only be done by such person or any other person acquainted with the handwriting of the author of such a document. Your Worship, the decision of the High Court in Civil Miscellaneous Application number 172 of 2011 of Plant Engineer and Trade Limited versus Joseph Chironde, the Honorable Justice Lame Kamukasa has ably guided on this issue.
Where's the authority?
I've given the citation to Council. High Court Civil Miscellaneous Application number 172 of 2011. You can search for it. We have internet even at court. Your Worship, we reiterate our earlier submissions and beg to present the original copy of the passport of the applicant, passport number A0011 9425.
And you see, Your Worship, me, I want to be clear. For a time I have practiced law, I wouldn't want to be in a situation where I am conflicted. You're taking a procedure which I never learned. Everything that my brother, including the issue of the passport, ought to have come out in the application. And they should have brought all that in an affidavit for us to verify. Because it is on record when it was not fair. And whatever document they never gave us was not verified. So we shouldn't prosecute this matter by ambush to make us make unnecessary interjections. Yes, we are right. We pray that that matter rests. Also,
Your Worship, we reiterate our earlier submissions and pray that this Honorable Court grants bail to the applicant, who is an honorable citizen who has served this country in the capacity of the representative of the President, who is the fountain of honor. It is only imperative that justice must not only be done, but the same must be seen to be done by balancing the rights of an accused person who is presumed innocent until this Honorable Court finds him guilty or he so pleads. Your Worship, we pray for very lenient terms for the applicant, and as court had directed the previous hearing, we have produced a copy, an original, pardon, passport photo, passport, I think you pardon, Your Worship, and his national ID for inspection of this Honorable Court. We so pray, Your Worship.
After hearing both sides, Magistrate Lonari Kaizi granted Anderson Burora bail with stringent conditions.
They still opposed the bail application, arguing among others that the first suit is not a wife of the accused person and that there are no records at the church where they were married, indicating that they two were married. that the LC1 letters of the sureties are forged and that the sureties have no financial capacity to pay the non-cash bond, the accused persons absconded. I have perused the affidavit opposing the bail application. I find that the LC1 chairpersons of all the LCs confirmed the authenticity of the letters by endorsing on the photocopies of the letters. No single LC rejected the letter as not being genuine, and all of them confirmed them to be genuine letters. There is no letter from the Mengo Church to confirm that the marriage between the applicant and the first surety did not take place. The applicant has complied with the paragraph 12 of the bail guidelines. He has provided to this court LC1 letters from the place of his residence and his identification documents. The state has called him a nomad that keeps on changing location. Be it as it may, the court takes his current residence to be his fixed place of abode. I find the suit is substantial and leaves the accused person on bail on the following conditions. One, the accused persons pay cash bill of 5 million. 2, each of the suits shall execute a bond of 50 million not cash. 3, the accused persons deposit his passport in court and does not leave the country without leave of this court. And D, the accused hereby ordered not to post on all his social media handles anything that relates to Right Honorable Anita Among or make reference to a personal office, and if it does, the bail shall be cancelled. This gang order shall remain in force until this case is heard and finally disposed of. Case adjourned the 22nd of August at 9 o'clock.
State filed an affidavit in reply to a bail application. They raised the several grounds, most of them which are not substantiated. We had considered making a formal reply, but then we agreed with court that the evidence, the documents we had adduced, were not attacked. The integrity remained. We elected not to file an affidavit in reply, and court agreed with us and accordingly granted our application.
Are you through with our conditions? Because we have not talked about the school of parliament, who has been in custody for over almost a month.
What was very important today was his freedom. The rest can be navigated after. Once he has got time to sit down and appreciate the matter, we'll discuss it with him. We'll see whether we can discuss others. But what is important right now is for him to gain his freedom. You see, they are the ones who started the case. It's their case. We have always been ready. The state has always been requesting for longer adjournments. From the day we started, we have been ready, and we are ready at any time it comes up.
Court adjourned until 22nd August 2024. The prosecution alleges that Burora Anderson demeaned and promoted hostility against the Speaker of Parliament, Anita Among, by calling her corrupt, a kidnapper, a murderer, using his ex-handle at HB